for what are debunked, frivolous, sovereign arguments.
And they want to say that they're not happy about it. What is the problem?
And the stranger was the one that actually shot you, not Mr. Barrison.
I had contact with her on the 20th. There was some physical. Mr. Brooks, this is my time. You need to not...
Right out of the gate, you can see the classic courtroom power struggle. The judge is asserting control, and Darrell Brooks is doing the exact opposite, interrupting, deflecting, and trying to dominate the narrative. But here's the thing. In a courtroom, control isn't optional. It's everything.
Interrupt.
That's the reason why the charge was dropped.
Mr. Brooks,
the state
you need to stop.
said specifically, wrote you, Your Honor, and said that they know it was no incident that day.
Mr.
And
Brooks,
now you want to sit up here.
do not interrupt me or you will be removed to the other
courtroom. And now you
courtroom.
want to sit up here
Stop.
and try to
now.
add something in that you know for a fact never even happened. You want to sit up here
Mr.
and talk
Brooks,
about
every
who
time-
has grace and all this. You talking about someone with 5 kids that don't have custody.
You need to stop
None of
right
them.
now or you will be removed.
Remove me then.
All right? He will be removed. He cannot simply stay
I don't
quiet
consent
when this
to be.
And there it is. I don't consent. This is a hallmark of so-called sovereign citizen arguments. Sounds powerful, right? But legally, it means absolutely nothing. Courts don't operate on personal consent. They operate on jurisdiction and law. So, the judge, not impressed.
Sentence anyway. I don't consent to this. Just like I told you, I don't know the.
We'll be in recess until he's
I don't
removed
even
to the other
understand
courtroom.
the true nature and cause.
This is adoption. What he was saying is improper arguments.
Okay, but what you are doing right now is highlighting something and making more of a spectacle. So if your office in general does not want to facilitate and or incite violence, then we need to just sit down and move on. That's it. There were 18 witnesses, 16 or 18 witnesses that testified today. There was nothing that was said until Ms. McNeil made her point made, and, you know, we're moving on.
But is the court going to do anything about maybe stopping it from happening again?
When these people are upset about specific things that have gone on from that table, like shooting the middle finger up at this court and laughing and joking, Ms. McNeil, be quiet. When these people have sat in this courtroom and watched this behavior from that table and they want to say that they're not happy about it, what is the problem?
Judge, I have no problem because I have thick skin. But once you bring in my children, I think that's highly improper. It's because
I didn't even know you have children. I don't know what you're talking about. Your children? What about your children?
First of all, Your Honor, this was the subject of a motion. I'm well aware of that. And the court left the door open.
For me, not for you.
My understanding of
You should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
That was not our motion.
Excuse me. I did. I granted.
We did not move
That
to
was
reconsider.
their motion.
We have not filed any
Forgive me.
motions to reconsider in this case.
That was their motion for reconsideration, which I denied. But I said I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law.
Now, this is a big moment. The judge calls out a violation of a fundamental legal principle, commenting on a defendant's post-arrest silence. That's protected under constitutional law. Translation: if mishandled, this kind of mistake can actually jeopardize a case. Stakes just went way up.
It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that, and it gives, well, I'll leave it at that. So I don't know what you're up to.
May I respond?
Yes.
We filed an other acts motion on this exact issue because in my mind, and I argued this, it is identical to what was going on the night of August 25th, in the sense that the defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect...
I'm not going to rehash the motion. Yeah, that's absolutely untrue. No. Your argument's of record. My comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest anything's changed. Even if you're correct in your assumption that you know more than I did at the time, you should have come to the court and say, I want to go into this. Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as the defense is pointing out, you're an experienced trial lawyer, and this should not have been gone into.
Your Honor, there have been things in this case, testimony in this case, that I believe opens the door to this. For example, the defense has introduced evidence that the defendant pointed a gun at a man wearing yellow pants because that person was on a car on the car source lot. Now, there's no justification that I can think of why the defendant would point that gun at someone. The defendant has just testified this morning that he agreed with that person in the yellow pants, that he pointed the gun at him. He said, I was joking when I said that to the guy in the yellow pants, but he's acknowledged that he told the person in the yellow pants, yeah, you're right, I did point a gun at you when you were sitting on a car.
He said, I did. That's what he
Exactly.
testified.
So he's agreeing. May I finish, please? I'd like to have a chance to make a record if I could, without being interrupted, if that's okay.
It
wasn't excluded, Your Honor.
You know why it was excluded in the first place? Because it was propensity evidence. That is exactly what 90404 is designed to prevent. You're talking about his attitudes. His attitude is he wants to shoot people. Now, I've admitted that kind of evidence in other trials when it's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the
Don't
defense testimony.
get brazen with me.
This is where the judge draws a hard legal line: propensity evidence. In simple terms, you can't say someone is guilty now just because they acted badly before. The law demands relevance, not character assassination. And the judge is making it crystal clear. This argument isn't getting past him.
You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. That's number one. Number two, this is propensity evidence. I said at the time that I made my ruling, and I'll repeat again now for you, I see no similarity between talking about wishing you had your AR gun, which you don't have, so that you could fire rounds at these thought to be shoplifters, and the incidents in these cases, which are not... There's nothing in your case that suggests the defendant was lying in wait to shoot at somebody or reflecting upon the shooting for a vast amount of time. Every one of the incidents involves matters that involve seconds in time. So I commented at the time, I don't see the similarity, and I don't see the similarity now. If it's not similar, that's the whole rule. Those are all the exceptions to 90404. Check the authorities. Wigmore and evidence. Judge Weinstein. Colonel McCormick. It's the prior act has to bear the signature of the accused, or it has to be so similar as to suggest it's a common plan or something like that. You have an incident where he's making comments about some alleged shoplifters versus crimes that involve instantaneous actions, whether premeditated murder or whether self-defense, that's for the jury to decide. But I don't see the similarity. I said it couldn't come in, and it isn't coming in, no matter what you think. Number two, I have to be concerned that with what Mr. Richards has said about the progress of the trial, and when you were I said you were over the line and close to or over the line on commenting on the defendant's pretrial silence, which is a well-known rule. I'm astonished that would have been an issue. So I don't want to have another issue as long as this case continues. Is that clear?
It is.
Thank you. Ask the jury to come back in, please.
That's not a subpoena. The subpoena is when you actually get the subpoena paperwork by mail, or I don't.
Mr. Brooks, you need to ask a question.
Can I get to it, Your Honor?
No, because you're trying to define something, which would be testifying, which you cannot do at this time. So the jury will disregard his last comment, but go ahead and ask a question of this witness.
Wow.
Mr. Brooks, that was inappropriate. Do you have any other questions for this witness? Please ask them. Would like to get through one more witness, but I want to take a short comfort break for everyone, so I'll rise for the jury. Thank you. Mr. Brooks, not now.
Not allowed to.
Not now. The jury is in this courtroom, and you will show respect for them and for this court.
Respect for them would be
Mr. Brooks,
telling them the truth.
stop. I'm putting you on notice that you are on the verge of this court.
Frivolous arguments. That's courtroom language 4. This is going nowhere. The judge is warning Brooks that if he keeps pushing these debunked claims, the jury might get a formal instruction to ignore them entirely. That's a devastating blow to credibility.
Creating a curative instruction about your frivolous arguments. I will not have you claim legitimacy for what are debunked, frivolous, sovereign arguments.
Then
that is why
prove it.
Your questions
Prove it.
are being
Prove that it's
objected
frivolous.
to,
Prove
and
that
why
it's frivolous. Prove it.
all the cases that we've already referenced, sir. We are in recess. We'll be back in
prove
5
it.
minutes. Thank you, everyone.
I don't agree to a estoppel. Can you prove it?
Away from the jury. How anybody in their right mind could listen to these proceedings this morning and report that, much less Elizabeth Williams of the New York Times. Why they have her covering this case when she
I
wrote
don't want to go down.
Judge,
Attorney Pattis, I don't.
May I please be heard?
No,
may I be heard?
No,
because I'll do it on
no.
the courthouse steps under 3.6b if
I suggest
I have to.
Attorney Pattis, I have made it so clear that when I'm speaking, you have to stop speaking. You've got to you just can't push it like that. You are welcome to leave this courthouse. In fact, you're welcome, I suppose you could stay in the courtroom and say whatever you want, but when I'm on the bench and I tell you to stop speaking, you need to stop. I'm going to say this again. I don't know how if I'm not making myself clear, and maybe it's my fault. I do not want to sanction an attorney. I do not want to fine an attorney. I have gone almost 2 decades as a judge and never had to do that. And I don't want to do it now. But if we have a continued problem where you're talking over me, I don't know what else to do. I've asked you nicely. I'm literally almost begging you. I have no recourse but to do that. So I'm not asking for your response, but you are certainly welcome to say whatever you would like to say when we're not on the record in the courtroom. That's your right to do so, and I know that you will abide the rules of professional conduct along those lines. I want to just get back and say this. I am responsible for what happens on the record in this courthouse, in this courtroom, and I am not responsible for any other issues. So I don't want to respond to that or go down and address any such statements. My concern was that there were safety issues or that that there were statements made to the families, the plaintiffs, or to Attorney Maddie, given that we had the issue earlier. But I am so happy that that is not the case. So I think we can move on from this issue. And I think hopefully you will use your powers of persuasion and we won't have any further issues where Mr. Jones is suggesting that the jury not follow their oath, frankly. So can we please move to the earlier filing about the curative clarifying charge? I don't think so, Attorney Pattis. I'm not giving you the opportunity. It's not a give and take here. I've said what I've said, and I think that is all I'm going to do on the topic. So are you prepared?
I'm begging you for an opportunity.
No, not at this, Attorney Pattis. No, I'm sorry. Do you want to be heard on your the curative charge now?
I have one more issue to raise with regard to the press conference, Your Honor.
Well, I'm not giving Attorney Pattis any further opportunity to address it. I think there's nothing at this point that I need to do. If you disagree, I encourage either or both of you to file something in the file.
No one was jumping up when they were referring to the defense children. No one jumped up to try to tap down that rhetoric. That is the rhetoric that I'm talking about. That is what I'm trying to be very clear on. Jeff, Marcus, the state, they can hide behind their arguments, but we all are witnessing what is occurring in this court.
Which is myself. I'm the judge,
and
I understand that I'm in
Thank you,
charge
Judge.
of the decorum, and I feel that 99% or a great percentage of what has been said has been appropriate. Everybody has maintained decorum, but for a few comments, it's best to just move on as opposed to highlight them.
This is true, Judge, but I am witnessing a building of momentum, and I'm encouraging the court to direct the state to tap down on that momentum so it does not reoccur and it does not become a theme. Thank you, Judge.
Your Honor, for the record, the only thing the state has said to any of these witnesses when they get up is, would they like to say something on behalf of the victim they're representing? There's been no encouraging or inciting, as Mr. Weeks has put on this record. That is a blatant falsehood and a recreation of the record. As far as no objections being made, it's the defense that could have objected. It's not the state's duty to object to their own witnesses when they're testifying.
Okay. Listen, I've already heard. If you have anything else to say, you can put it in writing at a later time. I've heard from both sides more than once. That's going to be it. I've made my decision. Like I said, 99% of what's been testified to has been appropriate. I do not want to highlight the few things that were said that were perhaps not appropriate, and let's move on. You can have as many seconds as you want in writing, and you can put all of your objections in writing. They've been made multiple times from your chief assistant, from Ms. McNeil, and I don't want to hear anything else. I've already heard it. Is there something that has not already been argued?
Yes, ma'am.
Okay, exactly what is it?
Judge, before Mr. Shacker going in to testify in the court's support, I wanted to reflect both Mr. Marcus and Mr. Satz looked at the statement and reading. And so their implicit adoption of what he was saying was improper arguments.
Okay, but what you are doing right now is highlighting something and making more of a spectacle. So if your office in general does not want to facilitate or incite violence, then we need to just sit down and move on. That's it. There were 18 witnesses, 16 or 18 witnesses that testified today. There was nothing that was said until Ms. McNeil made her point made, and, we're moving on.
But in this court, when did you do anything about maybe stopping it from happening again?
When these people are upset about specific things that have gone on from that table, like shooting the middle finger up at this court and laughing and joking, Ms. McNeil, be quiet. When these people have sat in this courtroom and watch this behavior from that table, and they want to say that they're not happy about it, what is the problem?
Judge, I have no problems. I am thick-skinned. But once you bring in my children, I think that's highly improper.
I didn't even know you have children. I don't know what you're talking about. Your children? What about your children?
For them to comment on my children is highly improper, and for this court to allow that kind of testimony is also
I don't remember any comments about any children. And if there was, it obviously didn't, it came and went without me noticing it.
Judge, I can assure you that if they were talking about your children, you would definitely notice it.
You need to sit down right now. You're out of line. In fact, you're excused. You need to go sit in the back with your chief public defender. Mr. Weeks, please ask the lawyer from your office to go sit down and not to say anything else. To try to threaten my children and bring up my children is inappropriate. Go to the back of the room now. That just violated about every rule of professional responsibility that I have never. If you're going to get up here and you're going to...
Judge, I asked you to go sidebar on this matter.
You, sidebar or not, you don't have one of your assistant public defenders say something about my children?
Judge, that same venom that the court is expressing is the same venom that defense counsel had to sit through this entire morning when their children...
She brought up her children multiple times during the trial. Nobody knows if I'm barren or not. They don't know about my children.
Judge.
Sit down. Sit down.
Judge.
Sit down, Mr. Weeks.
Please do not summarily dismiss me.
I'm summarily dismissing you.
The
Go
court,
sit down.
I'm asking the court. I asked the court to go sidebar.
Go sit down. You don't threaten the
Judge,
court's children.
everyone
Your
in this
assistant just
courtroom-
did that. Go sit down.
No one in this courtroom had to endure what we had to
Go
endure.
sit down. Miss McNeil has made her children a spectacle more than once during this trial. That was her choice. You have absolutely no right to have one of your assistants come up here and suggest something about my children. Now, please go sit down.
Judge.
You're inappropriate and out of line. Go sit down.
Judge, may I have a brief recess?
No. Go sit down.
May I have a brief recess so I can speak to my attorneys?
We're moving on with the sentencing, Mr. Weeks.
Can I have a brief recess?
No.
Thank you.
It's 1:36. Thank you.
What you're doing is judicial misconduct. Judicial misconduct. But you don't want the jury to hear the truth. That's not fair to the jury. They have a right to hear everything. I'm not finna sit here and let you fix the trial because you don't want to tell the truth to the jury.
Mr. Brooks, please stop.
No, ain't no please.
You are
nothing.
being disruptive.
Ain't
You
no
are being
please nothing.
disrespectful.
You always
The
gonna
witness
find
may
some
step
reason to
down.
say somebody's being disruptive because they want the truth to be out there. Man, quit it. You're supposed to be the
Mr.
judge.
Brooks, I'm advising you that continued interruptions will result in you forfeiting your right to be present.
And here's the breaking point. Removal from the courtroom is one of the most serious actions a judge can take. It means the defendant has crossed from disruptive into obstructive. The trial doesn't stop, but now Brooks loses the ability to directly influence the room. That's a massive shift in power.
In this
Under what law and fact can you do that?
Illinois versus Allen.
Okay,
sir.
but the fourth option that you made up, that's not even in the law.
Mr.
Because
Brooks,
you can't do that.
I need to make a
By law,
ruling.
you can't do that.
I need to
And
make
you
a
know you
finding.
can't.
All right, I'm going to excuse everyone. Mr. Brooks is being removed from the courtroom. He will continue in the neighboring courtroom. Please make sure he has his objection signed and a pad of paper.
So is that
he can.
So is that holding me in
meaningfully
contempt?
participate, and I will make a ruling when I.
So are
after
you
we
holding
come
me in
back up.
contempt? Is that civil or criminal?
Now have a chance and a right to come in here and say what they're allowed to say and what they're legally allowed to say. What the defense is doing is illegal to try and curtail these victims' rights under the law, and it's unconscionable. These victims have a right to express themselves. I have not gone over what their statements are because under the law, under Chapter 960, They don't have to tell me what they're going to say. They can ask me if they need guidance, and I will provide it to them. But they have a right to address this court. Thank you, Your Honor.
State, you can go ahead and call your next witness.
I just need to say that the defense is not attempting to curtail the limits of the sentencing proceeding or the rights that the victim's families have. We are not trying to do that. But the state attorney's office knows that what is happening here is beyond what the victim's families are constitutionally protected to do. You can say whatever you want to Mr. Cruz. You can attack him.
Bringing up irrelevant matters. I told you yesterday, as a courtesy, that was provided to you so that you would frankly not complain that you didn't get it as quickly as possible. Okay? I am not the custodian of the records. If you have an issue with what was provided to you, how it was provided to you, then take it up with the clerk of court. But from now on, I am not going to be the messenger and give you documents that you request to the custodian of the records or from the custodian of the records. They will simply have to be delivered to you at the jail. But that is in response to your discussion or whatever we want to call it this morning. I'm not taking it up. All right? It is irrelevant.
It needed to be noted for the record.
It doesn't need to be noted, sir. All right? The jury's coming back out, and I'm going to warn you, if you bring this up again, I will pause and I will remove you to the next courtroom for being disrespectful, for being interruptive, for being disruptive, and for bringing up irrelevant matters in front of this jury. You will forfeit your right to be present for the direct examination of this witness.
I object to that.
Did you hear what I said, sir?
No, I did not. I object to that, Your Honor.
Well, you can object, and your objection is noted. But if you
For the
interrupt
record.
when this jury
For
comes
the
out,
record.
they will go. I will have them taken out again, and you will be removed to the next courtroom.
You can't. What is the legal basis for that ruling, Your Honor?
Illinois versus Allen, sir, and all of the
And-
other cases that
and it
I've
doesn't
cited
say
previously.
anything
I'll
that-
make the appropriate record. Stop interrupting me. The jury's coming out. We're continuing with this trial despite your repeated efforts to disrupt.
That's a
Yesterday,
mischaracterization
sit
of the
down.
record.
Yesterday alone, sir, 17 interruptions, not including the opportunity that I gave you where you spent 15 minutes, okay, discussing what were primarily either irrelevant or baseless accusations and requests not based in law or fact. I was abundantly patient with you yesterday.
And you still haven't
And-
verified by proof any of what I
And
said,
none of
Your
that
Honor.
is required, sir.
Because it
And
is. You can't verify.
your
any proof.
belief
Where's
that
the
that's the
subject matter?
law
Where's the subject matter
doesn't make it
jurisdiction?
so, Mr. Brooks. Your belief that these are legitimate legal positions
They are.
doesn't change the law and doesn't make it so.
It's
So,
clearly
again,
relevant because you didn't want to.
I'm going to step off and give Mr. Brooks 5 minutes to cool off, and when that
I don't
happens,
need
I'm
to
bringing
cool
the
off.
jury
I'm
out,
not angry at all.
and then we will
I just wanted
continue.
to. I don't.
Believes that. Have you given them everything you're going to show them during opening statement?
Your Honor, I haven't given them all of the word slides. I did give to them what Mr. Williams objected to. I had given that to them previously. I will give them or share with them the things that have been added as of this evening. And
Can you do that over the next 5 minutes?
I sure can.
Deputy Ingram, Ingram, can you find out if our jurors are ready? Are they ready? Are they still using the restroom?
I'll send that to them right now as we're waiting.
Your Honor, Your Honor, Jay Apt on behalf of Mr. Kendrick, can we have 5 or 10 minutes to review whatever Ms. Love is going to send us?
You can take a comfort break, and I'll come back at 10 of 12. And like I said, whatever we don't finish before 12:15, we'll pick up after lunch. Okay?
Thank you, Your Honor.
Who's talking?
Sharp.
Yes, Mr. Sharp.
On behalf of Mr. Stillwell, we've been operating pre-trial with the Harvey rule. I want to make sure that the record is clear that we join Mr. Steele in his motion for mistrial, and if Your Honor...
I'll apply the Harvey rule unless you tell me otherwise.